Good morning, friends. Now, this is my 274th video. Now, this video is very important, and I want everybody to watch this video very seriously and listen to the last. How land is defined in various laws in the Constitution. I'll be reading. Land in civil law comprises not only the surface of the ground but also everything on or over or under it. For ejus est solum ejus est, usque and coelum est and inferos. This is a Latin word. Under the English Conveyance Act 1881, Section 2, unless a contrary intention appears, land include land of any tenure and tenement and hereditments, corporeal or incorporeal, and houses and other buildings, also an undivided share in land. So, land includes minerals, things attached to the earth. Besides water, the term land includes also things attached to the earth. It is used here in the same sense that is it means things rooted in the earth, as in the cases of trees and shrubs, things embedded in the earth, as in the case of walls and buildings, things attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached. The term attach does not mean physical fastness. So, what is the interpretation in the maxima which speaks on this? So, the maxima pura autur levi is a legal term that refers to properties in trust that lasts for the duration of another person's life. It is a type of life estate and is used in countries with a common law background such as United States and some Canadian provinces. Now for the French, autre vie means other life, and entrust in property for the lifetime of someone else. If A is given a property for B's life, A is the tenant, is pur outre vie, and will hold the property during the lifetime of B. The sestu QV. If A dies before B, the person entitled under A's will or on his intestacy will take the interest for the remainder of B's life. If B dies before A, A's interest thereupon terminates. The interest is a kind of life interest and an estate of freehold such that it could be inherited since 1925. It has been an equitable interest only. What does sestq v is a legal term that means he who lives. It is used to describe the beneficiary of a trust or insurance policy. The term is also used to describe the person whose life determines the length of an estate. Now, what is sestio QV? Seste QV is a French word, he who lives. It is a legal term for an individual who is the beneficiary of a trust or an insurance policy with rights to property and the income and profit that the property provides. Assess the Q trust is the person entitled to an equitable rather than legal trust in the estate's asset. The concept is also used in modern life and health insurance policies, where SESTQV is an individual whose life measure the duration of the insurance contract. In these contracts, SESTQV is known as the policy holder, insured, or policy owner. Thus, while the term refers to the beneficiary of a trust or estate, it often refers to the insured and not the beneficiary of an insurance policy. So, where does this real estate definition comes from? Friends, these are various definitions used in the cantonment laws, in the GGOs, and various places how we need to define land. Now, what does real estate? Is a form of real property, meaning that it is something you own that is attached to a piece of land. It can be used for residential, commercial, or industrial purposes and typically includes any natural resource on the land, such as minerals or water. Now, real estate is a property consisting of land and the building on it, along with its natural resources, such as growing crops, for example, timber, minerals, or waters, and wild animals. Immovable property of this nature and in trust vested in this also an item of real property, more generally buildings or housing in general. Para 1, in terms of law, relates to land property and is different from personal property, while estate means the interest a person has in that land and property. 3. The real estate is different from a personal property, which is not permanently attached to the land or comes with land, such a vehicle, boats, jewelry, furniture, tools, any kind of rolling stocks of farm or farm animals. Now in United States, the transfer, owning, or acquisition of real estate can be through business corporations, individuals, non-profit corporations, fiduciaries, or any legal entity as seen within the law of the US state. Now we will read the history of real estate. The natural right of a person to own property as a concept can be seen as having roots in the Roman laws as well as the Greek philosophy. The profession of appraisal can be seen as beginning in England during the 1500s as agriculture needs required land clearing and land preparation. Textbooks on the subject of surveying began to be written, and the term surveying was used in England, while the term appraising was no more used in North America. Natural law, which can be seen as a universal law, was discussed among writers of the 15th and 16th century as it pertained to a property theory. And the intrastate relation dealing with foreign investments and the protection of citizens' private property, natural law can be seen as having an influence in Emmerich de Vettel's 1758 treatise, The Law of Nation, which capitalized the idea of private properties. Now, here I'm going to read some names. Messages, tenements, hereditaments are the terms used to describe real property. including land, building, and any right associated with them. These assets can be bought, sold, inherited, or transferred legally. Now, here I'll make a full stop and count on to people who have shared their registries with me. Mr. Jalnawala, Ahmedabad, if you read your sale deed, what are the words used? Hereditaments, tenements, massages. Anybody whose registry is prior to 1882 Transfer of Properties Act is subscribed with these words. That is why I read this entire briefing, so that you people can understand what am I trying to say through this briefing of mine on land. Now, second, land means lands, the acquiring, the taking, or using of which is authorized by this act or a special act, and includes real property, massages, lands, tenements, and hereditaments of any tenure, and any easement, servitudes, rights, privilege, or interest in, to, on, under, over, or in respect of the same. Is anything left? Wake up, guys, wake up. Now, where is the problem? The problem is the English version of the definition of land uses uniquely common law concept. Some of the terms used are archaic or of a little practical application, and the meaning of many other overlap. So what does the French version says? On the other hand, is much more general, but also contains confusing terminologies for the civil law audience. For example, privileges. So what is the solution which the English found? The English version, the phrase massages, lands, tenements, and hereditaments of any tenure and any easement, servitudes, rights, privilege, or interest in, to, on, under, over, or in respect of the same is replaced by and any interest or right in real property or land and in the provinces of Canada or Quebec, and especially any immovables, any rights in immovables, and the rights of a lessee in respect of any immovables. Those interests and rights may be in, to, on, under, or over in respect to of these lands. So the French version of the phrase Bayern fons battens et dependence di tot sorot q sua truvent et oxydrots servitudes etc privilege gervant la surface oliosos law des terrains et ses biens is replaced by biens real or interest foncier. So, not getting into the details of the French language, so these are the variations which have been used in French terminology. So, what was the last in the harmonized provision? Lands means land, the acquiring, taking, or using of which is authorized by this act. So these acts were in place, and the common law, a herdiment, from Latin herditare, to inherit from hers. Hers means hair, legal hair, is any kind of property that can be inherited. So I've explained the meaning. Now, hereditments are divided into corporeal and incorporeal subparts. Corporeal hereditments are such as affects the senses and may be seen and handled by the body. Incorporeal are not the subject of sensation, can neither be seen or handled, are creatures of the mind and exist only in contemplation. An example of corporal hediment is land held in freehold and in leasehold. So, this is what? Now, another example, hediments are hereditary titles of honor or dignity, heritable titles of office, coats of arms, and prescriptive baronies, pensions, annuities, rent charges, franchisees, and other interests having no physical existence. So, incorporeal hediments. Two, two categories related to the church have been abolished in England and Wales and certain other parts of British Isles. The tithes and the adoptions. The term featured in the one-time sweeper definition. Catch all phrases, lands, tenements, and hereditaments is depreciated in contemporary legal documents. The term land, building, and where such land is unregistered, apparent rights, invariable, coupled with itemized list, more properly described property, respectively forming and connected with the land as distinguished from goods and chattels or movable properties. So we can discuss some other meanings also in the same format of land. In the UK, the word is used in annual property taxation. It practically defines being the answer to the question. As a matter of fact and degree, is or will the building as a building be ready for occupation or capable of occupation for the purpose for which it is intended, combined with tests surrounding whether it is a dwelling and case law decision, for example, whether other structures than homes such as garages form part of the hediment. The addition or reduction of small parcels of land constitutes a new hediment. Now, this part is in a lot of sale deeds in the cantonments which I have. They speak of hediments, garages, passage, massages with garden. Why? This is why it speaks, because the Britishers were looking for all this. They wanted these words to be inscribed because these were freehold properties. Why? Because they were revenue free grants. Corporal properties is a physical object that can be seen and touched, while incorporeal property is a right that is not physical. Now, what does corporal ownership mean? Is the ownership of material things. It is the ownership of things that has physical existence and is capable of being seen and touched. So, ownership of land, money, machine, or building is corporal ownership. On the other hand, incorporeal ownership is the ownership of a right. For example, let's say the ownership of an intellectual property is incorporeal ownership. So, where are we leading to? Everything is to be brief. Now, chattel interest, there is a sale deed where I had this word, is a legal interest in land that is less than a freehold estate. Chattel can also refer to movable personal property. So, chattel was basically inscribed in these properties. I'll make you understand. In the British time, because these were immovable, movable items like chairs, furniture, everything was part of the sale. In the legal and financial world, chattel refers to movable personal properties. Chattel's value can drop rapidly due to depreciation, as is often seen with new cars, and typically does not increase with improvement or renovation. So, my point gets cleared. For these reasons, chattel properties is treated differently from the real estate for taxation and accounting purposes. This is so important what I'm trying to explain you people. Now, the additional legal system treats the rights to chattel property differently from the right to real property. The right to real property typically have no longer statute of limitations and are harder to overturn. Now, chattel property can be movable between locations as opposed to real property, which is on fixed location. Common example includes mobile phones, furnitures, automobiles. These articles, what chattel is and how it is used as security in chattel mortgage. Chattel is a term for movable properties in persons. So we need to understand why this word was inscribed in various sale deeds. So, friends, different properties have different consequences. Different sale deeds, when are read through, have different meanings. So that is why, people used to tell me, Mr. Das, now I'm telling you all in facts. Why I've been telling people every court case will have its own evidence. So, friends, please don't harp. I'm being very honest that because of Mr. A will win or Mr. Das will make him win, so we will win. Your records, your sale deeds, your documents will speak, and only then you will. A personal estate is a person's movable property or the right to use or possess certain items. It's different from real estate. So we need to understand what is the difference between personal, corporal, real. Personal estates is a type of property that belongs to a person. It includes things that a person owns, like their clothes, furniture, and money. Personal estates, a different form of real estates, which is land and building. When person dies, their personal estate is usually given to their families or friends. A more thorough explanation can be done on this. Cars, piece of jewelry. So another example could be bank accounts. Accounts holders, our rights are transferred overall. So these are more related to personal property. So now I have defined properties in a very chronological manner. Why? Because people, you need to understand, we are addressed at estate. We are never told that we are a property. Does this property include land? The tax structure or the tax superintendent says, I am only charging you because you're the owner of the building. How can we segregate a building from land? So that is why this video was there. I hope you understand. Once again, I've been continuously saying we guys are old grants, revenue free grants, never converted into new grants through either of the regulations of the British, maybe GGOs, maybe any, because all were Governor General orders. Some were specifically for army or military stations, and some were for civil areas. So, friends, we just have to understand this and then we can achieve and we can all understand. Let this video reach your advocates. Thank you. Good day.